Hi, I'm Amber Sliger of the Sliger Law Firm. I'm a personal injury attorney and I take care of injured victims in Colorado. I handle predominantly complex litigation and complex liability cases. And often when people give me a call, their first question is, do I have a case? That's what we're going to talk about today. So, do you have a good case? If you've been injured in an accident, you're probably wondering whether you have a strong case. The answer really is that it depends. These 8 factors are the primary ones determining whether or not you have a strong personal injury claim. First, there's liability. Liability essentially is a breach of duty to use reasonable care. Proving liability is the first and biggest hurdle in your case. Now, this is especially true in the smaller personal injury cases. Insurance companies have no fear about rejecting claims in small cases in which there are serious questions as to liability. Basically, if the defendant's fault or responsibility is unclear, then so is your chance of achieving a favorable outcome in your case. Now, second, once you get past liability, you do have to prove damages. Even when liability is clear, you have to have damages, or you have no case. Damages are the harm that was done to you in the crash, including your past and future medical bills, as well as your pain, your suffering, your out-of-pocket expenses, and any permanent impairment. The damages factor cannot be fully assessed at your initial interview because the extent of your injuries is still unknown at the beginning of your case. However, even in the earliest stages of your case, you probably have some idea as to the potential severity of your injuries. Some damages are easy to see. A broken bone shows on an X-ray, but the impact this has on your body, how it feels, how the injury changes your life, is something entirely different, but is also a damage. If your injuries are such that it's easy to see the damage, your burden in proving your damages is significantly easier. Third, you want to think about the ability to pay. The defendant, or the person who wronged you, has to have assets for you to collect. If not, you and your attorney may invest a good deal of time, money, effort, and most importantly, emotional energy in the case, and never see a penny in return. Either some type of insurance must cover the crash or incident, or the defendant must have personal assets, like property that can be sold to pay the judgment. Now, fourth, will the jury respond to you as a person? Will jurors empathize with your situation? Also, what kind of person is the defendant? Will the jury like the defendant and find them therefore more believable than you? There are some bad defendants out there. The obvious ones, the drunk driver or, the bully. If you have an unlikable defendant, your settlement range goes up. But even more importantly, if the jury doesn't respond to you as a person or doesn't believe you, your settlement range could go down because adjusters can recognize that a jury may not respond well to you based on statements that you've made in the case. Number 5, witnesses. As the plaintiff in a case, your case is only as good as your evidence, and you have the burden of proof. And usually your evidence is only as good as your witnesses. If, for example, your only witness to support the wrongful act of the defendant is a relative or a friend, your case is not as strong as if this same testimony was given by someone who didn't know you, that just happened to see the events. Your doctor might be a witness to the medical part of your case. If the doctor involved has never testified, doesn't want to testify, or cannot testify well, this also lowers your potential settlement value. Number 6, how tight-fisted is the defendant's insurance company? As lawyers, we are familiar with which companies are the most tight-fisted and will make ridiculously low-ball offers. On the other hand, if your carrier is fair, and some of them are, you can count on a higher settlement offer. However, these insurance companies are changing their metrics and the way they do business all the time. So you need someone who regularly deals with these companies to see when they have shifted to a more tight-fisted approach to these cases. Number 7, how much time has passed since the incident that caused your injuries? As a general rule, if your case takes a long time to get to the jurors, they will be less sympathetic to your injuries. This is particularly true if you experience pain or other symptoms for a limited time of the accident, but you have fully recovered at the time of trial. Number 8, how much damage can you see in the photos? In many automobile cases, the actual damage to the automobile may be minimal because car bumpers are designed to absorb more impact than they could many years ago. If there's only a bumper scratch or a minor fender damage, the jury is going to question the extent of the impact and therefore the extent of your injuries. On the other hand, if the car you were in has significant damage, jurors are more likely to understand that someone would be damaged in that crash. These are some of the factors impacting your case. They're not the only ones, but it's a good place to start so that you understand some of the things that we are going to be looking at in your case. To recap, the primary factors determining the strength of your case are: how clear is the defendant's liability? Do your medical records support your injuries? Will the defendant or the defendant's insurance have enough to fully cover your losses? Will a jury respond to your plight and agree with your actions? And will the jury dislike the defendant and the defendant's actions? Do witnesses who are unbiased support your claim? Does the insurer have fair settlement practices? Will you be fully recovered by the time of trial? And in auto crash cases, how visible is the damage to the vehicle?